Cool. So on your question, if so, this gentleman is abroad. He owns a property in South Africa, and for some reason, he can't seem to get a bank account open in South Africa. And instead, he asks his friend to just take care of certain things for him, to hold the deposit, collect the rentals, maybe do a little bit of the administration, calls the guy and when something breaks. Now, is this permissible, or could this be a problem?
Perfect. So, obviously, in terms of this question, it's not unknown that sometimes we have property owners who don't reside within South Africa, and they have property here which they rent out and use as an investment property. And in those circumstances, it's very common for that particular owner to utilize someone to assist them with the legwork here in South Africa. Now, obviously, in majority of circumstances where this happens, you're generally going to find that an owner goes and finds a property practitioner and mandates the property practitioner to do whatever functions they need and deal with their tenants in the circumstances. And in this particular question, however, we've got an owner who's overseas and they want to get their friend to help them to manage or to hold, they say, hold the deposit, maybe hold the rental and pay off rates and whatever the case is in respect of the particular property. Now, the real crux of this question now lies on, does the actions of this particular friend in the circumstances fall foul of the legislation applicable in South Africa? So, as I'm sure all of us will know, in terms of South African law, we have what is called the Property Practitioners Act of 2019. That act regulates the conduct of property practitioners within South Africa. And what's important about this particular act is Section 48 of that act specifically prohibits any person from performing what are deemed in terms of the legislation to be functions of a property practitioner without that person either holding a Fidelity Fund Certificate or working for a company or an entity that does hold a Fidelity Fund Certificate. So in other words, property practitioners in South African law have to have a Fidelity Fund Certificate in order to act as a property practitioner. The reason that this is the case is you are in a position where you are holding money on behalf of other people. Okay? In other words, you are in a trust situation. You are expected to have a high enough standard and to be trustworthy enough that you can hold other people's assets, their money in the circumstances, and you need to be in a position where you are there's a license in order to demonstrate that you are able to do this with sufficient trust so that you don't just walk away with people's money. Property practitioners are an example of people who have to have this. Attorneys are people who also have to have a Fidelity Fund Certificate. So it's just some level of security to ensure that this person is entitled to hold your money. Okay, that doesn't necessarily mean that your friends can't hold your money in the circumstances. Okay, obviously, if you have friends, you can give them money to hold on your behalf. That's between you and your friend. However, where this gets very difficult, okay, is what is expected, what the friend in the circumstances expects as a result of them helping you out in the circumstances. So if Bruno and I are having a transaction, we're just acting as friends, and I'd say to him, listen, will you hold, some money for me, 5,000 Rand for me? That's absolutely fine. We're entitled to engage each other on that basis. The trick is, in terms of the Property Practitioners Act, if you are expecting to get some sort of remuneration back as a result of that, and specifically the Property Practitioners Act uses the word gain, okay? Mm-hmm. So if you're expecting a gain of some kind as a result of your helping this person out, you are going to fall foul of the Property Practitioners Act, and then you're going to have violated the provisions of the legislation. All right. Now, in terms of the particular act, the word gain is not specifically defined. So when it comes to assessing the particular facts of a case, okay, Bruno and I actually had a nice argument before we came on today, because we're having a debate, as lawyers do, about what does gain mean? What exactly is a gain in the circumstances? But for the purposes, we'll leave the argument aside. If you are deemed to be receiving a gain, okay, for performing these certain functions, even if you say this is my friend, you are going to fall foul of this particular legislation, and there are going to be penalties that are applied to you in terms of this particular legislation. So the real question in terms of this question is, can you ask a friend of yours to particularly, perform certain functions on your behalf? Perhaps, okay, absolutely, perhaps, if they are helping you out. But the minute this turns into a circumstance where that person is expecting some sort of remuneration or gain as a result of performing those functions, they are absolutely prohibited in terms of the Property Practitioners Act. There is no question about it. And on top of this, please remember, in respect of the deposit, because specifically they said that they want to give this deposit to someone to hold on the landlord's behalf. Remember, as a landlord, if you are going to let someone else hold the deposit on your behalf, please remember, you as the landlord are responsible for that deposit. That deposit is not your money to do with what you want. When you hold a deposit on behalf of a tenant, it is the tenant's money, okay, that you are holding in security. Okay, you can't just use the deposit as you want and put it wherever you want. You have to hold it on their behalf, and you have to hold it in terms of an interest-bearing account as is set out in the particular legislation. All right. So please don't forget, if you are a landlord in the circumstances and you're going to do something like this, please remember you are specifically responsible for that tenant's money and the deposit in the circumstances. If your friend in the circumstances does something funny with the money, or it, uses it, or whatever the case is, you are not going to be able to have an argument and say, he did something to the money. You are the one who's ultimately responsible for that particular money, and you specifically are responsible to make sure that whatever happens to that deposit is in line with the legislation. In other words, it is invested in an interest-bearing account with a registered financial institution in South Africa. So there's also a risk, if you are the landlord in the circumstances, that you will face if you don't follow the legislation. So is it possible? Yes, under some very strict circumstances. Obviously, the recommendation here is, if it comes at all to a circumstance where there's going to be some quid pro quo, and remember, the legislation says gain. So even if you've got to buy your friend a beer, that's gain in my world. Please use an estate agent, use a registered estate agent with a Fidelity Fund Certificate. For anyone else who's listening, when you go to your estate agent, ask for their up-to-date Fidelity Fund Certificates. They are issued every single year to make sure that you don't get yourself in trouble, because ultimately, as the landlord, you are responsible for that.
Absolutely. Thanks, Nick.
Perfect. Thank you, Bruno, and we will see you again next week.
Awesome. Cheers.
Cheers.